Welcome aboard, applicants. We're going to be talking today about torts. I thought I might take some time here and just explain our shopping list a little bit in some detail, and I think that's appropriate and it's an excellent review. So I feel that this is a great time to get caught up on our torts. So with that being said, let's get into torts. Torts begins with our shopping list. You can supply your own shopping list or checklist, but ours is intentional torts, negligence, strict liability, products liability, other torts, which is what we have the acronym of Swiss Mini, third-party torts, joint and civil liability, vicarious liability respondeat superior, and abuse of judicial process. Now, with this shopping list, we can actually go into our hypotheticals and be able to issue spot all the issues that those facts raise. Now, let's go into our review now of torts. And especially now, we'll begin with the top of the list, intentional torts. Intentional torts, obviously, as the name says, involves intent. Intent has two definitions. Intent is either desire that an outcome occur, or having knowledge, I should say knowledge to a substantial certainty. That a particular course of conduct will result in a specific outcome. So what we have in terms of torts is in terms of intentional torts, is the definition of intent: a desire or action with knowledge to a substantial certainty that a particular outcome will occur. Now, I also look for transferred intent. And remember, intent can transfer from tort to tort and person to person. Now, specifically after we've established intent and whether or not transferred intent applies, we will now go into our intentional torts, beginning with the intentional tort, assault. Assault is an intentional act by the defendant that causes the plaintiff to suffer reasonable apprehension of receiving a harmful or offensive contact. So we have intent, causation, and then we have reasonable apprehension and harmful or offensive contact. Okay, that's assault in a nutshell. Now down to the next intentional tort, battery. Battery is intentional act by the defendant that causes the plaintiff to suffer a harmful or offensive contact with their person. Now, intent is the first element, causation is the second element. The next element is harmful or offensive contact, and then some people even bring up plaintiff's person, so we throw in person here. Now, person can also mean something closely connected. So you could say something that is closely connected to the plaintiff's person. Okay, and then harmful or offensive contact. Harmful contact is oftentimes those situations in our hypotheticals where the plaintiff suffers a injury, severe injury. Now, offensive contact would lower the esteem of the plaintiff in the community of their peers. Okay, so we need to be looking out for batteries of that type as well. Sometimes they do show themselves in our hypotheticals. The next intentional tort we could talk about is false imprisonment. false imprisonment. Oh, let's make sure I got this spelled right. Yep, there it is intentional act by the defendant that confines the plaintiff to a bounded area with no reasonable means of escape. Intent, causation, confinement, bounded area, and no reasonable means of escape. Okay. Make sure I got this spelled right. Okay, excellent. Now, the next intentional tort we're going to be talking about is trespass to chattels. This is an intentional act by the defendant which interferes with the possessory interest of the plaintiff in their personal property. Interference with possession, personal property of plaintiff. Now, the next intentional tort would be conversion. Now, conversion is the intentional act by the defendant that causes a substantial exercise of dominion and control over the plaintiff's personal property. So much so that some people would say that there is required for sale. Intent, causation, interference. Or with this, it's not. It's substantial dominion and control plaintiff's personal property. All right. Now, the next, and I believe the final intentional tort that we're going to be talking about is trespass to land. And this is an intentional act by the defendant that causes an entry onto the plaintiff's land. Now, intentional act, or intent, causation, entry, land of another. In this case, it would be the property would belong to the plaintiff. Okay. Now, we have all of our intentional torts all sorted by the elements. We want to make sure I'm going to put an asterisk by the ones that have the potential to have their intent transfer. There are only two that cannot have their intent transfer. So we have assault can have its intent transfer. Battery can have its intent transfer. False imprisonment can have its intent transfer. Trespass to chattels can have its intent transfer. Conversion. And we don't want to forget at the bottom of this a very important one called intentional infliction of emotional distress. With intentional infliction of emotional distress, we're looking at intent basically, here's the definition of intentional infliction of emotional distress. Extreme or outrageous conduct by the defendant that intentionally or recklessly causes the plaintiffs to suffer severe emotional distress. So we're taking a look here at not only is it intentional, but it can also be reckless. Intentional or recklessness extreme and outrageous conduct by the plaintiff, by the defendant, excuse me, that causes the plaintiff to suffer severe emotional distress. Okay. Now, trespass to land. Oh, let me say, conversion cannot have its intent transfer. Trespass to land can have its intent transfer, and intentional infliction of emotional distress, unfortunately, cannot have its intent transfer. So let's look through here. The only ones in our intentional and tort list that cannot have its intent transfer is conversion and intentional infliction of emotional distress. Excellent job. Now, concerning our defenses, which we should always be looking out for, would be consent, self-defense, excuse me, defense of others, defense of property, authority, shopkeeper's privilege, retaking own chattel, and most likely necessity, both coming in the forms of private necessity and public necessity. Okay. Now those would be the go-to defenses for our intentional torts. All right. Now we're going to switch gears and go into negligence. Negligence is when, okay, negligence is present when, oh, self-abatement. Excellent job too. We should probably throw that in there. We'll throw that in there as well. Excellent job. Excellent. Self-abatement is another way of saying like self-help situations where you can possibly come onto the land of another to negotiate, and if there is a situation that requires a self-help. Okay, so that would be excellent defense. Great job. Reclaiming own property. Yep. Retaking own chattel. Reclaiming own property. Reclaiming own property. Excellent job. Very well done. Excellent. Very good. Now, under negligence, negligence is when the defendant owes the plaintiff a duty and they have breached that duty, and such breach of that duty is the actual and proximate cause of plaintiff's injuries. So the elements required for negligence are these: duty, breach of duty, actual cause, proximate cause, damages, defenses. And so now under duty, we're going to be looking at two types of duty: general duty and special duty. Now, a general duty begins with the reasonable, prudent person. And with the reasonable, prudent person, we should assess whether the defendant has acted as a reasonably prudent person within the same or similar circumstance. And same or similar circumstance encompasses all sorts of different things concerning that reasonable person. That reasonable person with the same age, that's the same disability, maybe even the same setting that the person would respond to. So that reasonably prudent person is not some isolated person, it adapts to the situation that the hypothetical is requiring us to analyze. And so that reasonably prudent person, though, nevertheless, is where we begin our our general duty analysis. Now, the special duty is when we take into consideration things like landowners, then we take into consideration like professionals, we take into consideration like innkeepers, public utilities, and common carriers. And we also don't want to forget too that we have oftentimes in our special duty, we got a child standard of care that we need to keep an eye out for. I'll put that right in here. Now, you might be asking, where is the Cardozo-Andrews opinion? Well, that's exactly what we're going to be taking a look at here underneath. Underneath our, after we've established general duty and a special duty, we need to be asking a special question underneath these: is to whom to whom is that duty owed? And when we talk about that, we're going to be talking about the special Cardozo or Paul's-Graf case where you got Cardozo saying that the defendant owes a duty to all foreseeable plaintiffs within the zone of danger created by the defendant's conduct. So we got zone of danger, Andrews, duty, and then Andrews in the Paul's-Graf case in the minority opinion stated that the defendant owed a duty to the world at large, the entire world. So that's after we've established what type of general duty, if that's applicable, special duty, if that's applicable, we ask ourselves whom is the duty owed, and that would be our foreseeable plaintiff aspect. Cardozo says the zone of danger. Andrews says duty to the world at large. Now that we've established whether or not a duty is owed, we ask ourselves, has that duty been breached? Now, under breach of duty, we're going to take a look at negligence per se. And under negligence per se, we're going to have class of persons protected. Now, negligence per se is a violation of a safety ordinance, a breach or violation of a safety ordinance or safety statute. And we got to assess whether or not the plaintiff is in a class of persons protected by the statute, whether or not the type of injury experienced by the plaintiff is the type the statute was designed to prevent, so type of injury. And then we're going to look to whether or not the defendant has any excuse for their conduct, maybe like an emergency situation of sorts. And then this should help us establish whether or not negligence per se has allowed us to establish a breach of our duty. Now, after negligence per se, we're going to be looking to see if there's a learned hand formula situation where the B is less than P times L. Okay, and all we're trying to do in this measurement for breach of duty is to establish whether or not the conduct by the defendant is unreasonable. And that's what we're going to look to see. Was their burden, to have acted differently less than the probability, the P, times the liability or severity of the harm? In other words, how probable was that event to occur, and how severe, if that event occurred, would that cause to our plaintiff here? And measure that against whether or not the the burden to have acted differently by the defendant is less than that. In other words, if it is indeed less than that, then our defendant should have acted in a more reasonable manner, and we should lay that out in our hypothetical as to what that more reasonable course of conduct should be. Now, remember, we should be taking into consideration as well things like social utility of the event and customs. So here, customs of the industry. And these things will help lessen the burden. We would add these to our burden if they're present in our hypothetical. We would take these into consideration in the form of like a risk versus utility analysis of sorts. With that being said, now let's switch gears or let's go into res ipsa loquitur. And in res ipsa loquitur, which is the thing speaks for itself, we are pretty much assessing the situation because the origin or cause of the event is very uncertain. So we got cause is possibly uncertain. And therefore we establish a three-prong analysis to determine whether or not our duty has been breached. First thing is, was the plaintiff did the plaintiff contribute, I should say this, did the plaintiff contribute to their own harm? The second prong we're going to look at was the defendant in the exclusive control of what we call as the harm-causing instrumentality. The defendant in exclusive control of harm-causing instrumentality. Oh, see if try to bring this over. See if I can. Okay. Let's try. Oh, I don't think that worked. Oh, oh, there. Okay. Let's see. Oh, you know what? I probably should just leave it as is. I'll leave that right there. I'll work with the formatting later. Okay, now also we want to make sure the first prong is met too. Thank you for your patience. And that is, would the event, in other words, the event would not have happened absent a presumption of negligence. So it's presumption of negligence. The event would not have happened absent that presumption. The plaintiff did not contribute to their own harm, or did they contribute to their own harm? And the defendant was in exclusive control of the harm caused or instrumentality. Let me just take exclusive control. There it is, of harm causing instrumentality. Now, okay. All right. Now, actual cause, we're going to be looking at, oh, and heads up, we're only going to be able to do negligence tonight because we have negligence is a big topic, and I want to give all of us a great review of it so that we can be prepared and do the best we can possibly do. So I probably only be able to get to negligence tonight, so stay tuned and we'll definitely get to the rest of the shopping list. Okay, but back to negligence now. Okay, actual cause. Actual cause is broken up into the but-for test, which is but for the defendant's conduct, the plaintiff would not have been injured. And then we look to the substantial factor test, whether or not the defendant was a substantial factor in bringing about the plaintiff's injury. This is heads up on this one. This is probably where you have multiple defendants. Now, after you've established actual cause, we're going to be looking, oh, and then we want to make sure, I should add one more in here, concurrent causation. And those are the situations where you have the Summer versus Tice situations. So you might, those, I haven't seen that pop up as much, but keep an eye out for those. But the main ones we want to keep our eye out for, the but-for test and the substantial factor test. If you have a concurrent causation situation, make sure to notify your reader that and appropriately apply the rule to the facts. Okay, now under proximate cause, we want to make sure to talk about foreseeability and intervening events. In foreseeability, we're going to take a look as to the foreseeability. When we talk about foreseeability, it's like we're saying was the course of conduct from the negligent conduct of the defendant to the result of injury to the plaintiff, was that whole chain eggshell? That's exactly right. Was that whole chain foreseeable? And we don't want to forget to talk about our eggshell skull plaintiff, which is the defendant is liable for the pre-existing conditions of the plaintiff, because the defendant takes their plaintiff as they find them. And that's what we want to look out for in foreseeability, is eggshell skull plaintiff rule. Okay, now under intervening events, we're going to be looking to see whether or not there's unforeseen, superseding, intervening events. I'll put that underneath this here so that it'll let's go right in there. Unforeseen, superseding, intervening events. These are the events that would break the chain of defendant's causation. Superseding. There we go. The classic examples of these would be acts of God, unforeseen third-party criminality, maybe even situations involving grossly negligent medical care, and any other form of unforeseen, superseding, intervening events. But those are the three classics. Okay, now on to right after proximate cause, we're going to be going into damages. General damages are the first type, and special damages. General damages, non-economic, and this would be like pain and suffering, loss of the ability to enjoy life. Special damages would be economic damages, and these would be out of pocket or lost wages, lost future earnings, out of pocket, medical expenses, maybe even replacement or repair of property that's been damaged, and the like. Now, make sure when you're talking about damages that you mention the damage, and then you talk about the general's damages, mention the damage again under special damage, and then talk about the special damages, so that in the reader can understand, or you can show your reader that you have appreciated the whole area of damages in both general damages and special damages. Okay, now under defenses, we're going to be looking at the three defenses for negligence: contributory negligence, comparative negligence, and assumption of the risk. Now, it's after contributory negligence, we don't want to forget the last clear chance rule. Okay, under contributory negligence, we're seeing whether or not the plaintiff has breached a standard of care. Under the traditional common law, contributory negligence was very harsh. It was a complete bar to plaintiff's recovery if they were contributory in any way to causing their own injury. Now, we have the comparative negligence, which is the modern law that comes along and lessens the harshness of the contributory negligence and says it's more of a fault apportionment system, whereby the plaintiff's recovery is reduced by their court-apportioned degree of fault. Now, but that's not where the story ends concerning contributory negligence. The plaintiff has a argument against the defendant, and this is the plaintiff's only argument, that the defendant had the last clear chance to avoid the injury and they didn't take such course of conduct. And so had they taken such course of conduct, they could have most likely avoided the injury in the first place. In other words, they had the last clear chance. Now, under comparative negligence, we have pure and modified jurisdictions. California being a pure comparative negligence jurisdiction. Intentional tort damages. Oh, right. Thank you very much. We will go up real quick and talk about intentional torts damages. Thank you for bringing that to my attention. Under intentional tort damages, we also want to talk about general damages and special damages. Thank you so much for bringing that to my attention. Up here we have non-economic and economic. Okay. Thank you again. Oh, and then we also want to talk about one special one for intentional torts. Thank you for bringing that to my mind too. Punitive damages. And this is where conduct taken by the defendant is willful and wanton conduct. So we're looking to see if that's in there. Punitive damages being damages get given by the court that essentially would punish the plaintiff to set the plaintiff as an example. So the defendant as an example for other defendants, so that the other defendants do not engage in such course of conduct. So this is punitive damages, willful and wanton activity by the defendant. And we also want to be looking for another one, injunction, in certain circumstances. And this would be equitable. Okay. Now, after talking about damages, intentional torts, we're going to come back down now to defenses, finish up our defenses discussion in negligence, and then we'll call it a day. As at assumption of the risk, we're going to be looking at actually two main topics here. This would be, first, you're going to look at whether or not the plaintiff appreciated the risk. Okay, and appreciating the risk is such an interesting thing, because sometimes what you might think a person may appreciate, a reasonable person in that same or similar circumstance may not appreciate it. Like, for instance, a child may not appreciate the risk that undergoing such a course of conduct may pose to themselves. So the plaintiff may not be able to, in that instance, to have appreciated the risk. But in other instances, a party may have appreciated the risk, and because of their maturity or their knowledge or their intelligence or their education, they may have that ability to appreciate the risk. And then when they appreciate that risk, they voluntarily assume such risk. Regardless of the outcome. Now, this is a form of assumption of the risk called implied assumption of the risk. And, well, this is actually implied here, because we have another type that we should also be on the lookout for, and that would be, I'll put it under here, implied, and I'll put these underneath implied here. Oh, there we go. We want to sometimes be looking out for expressed assumption of the risk. And these are, like, for instance, the type of assumptions of the risk that would be like consent forms to consume or concerning assuming the risk for certain courses of conduct. And we want to be looking out for those types of hypothetical fact patterns and be able to spot those as assumption of the risk defenses. So again, the main one though for assumption of the risk that we want to keep our eye out for is implied assumption of the risk. The plaintiff appreciated the risk and they voluntarily assumed such risk regardless of the outcome. Now, that should pretty much bring to a close our review of negligence. Okay, I put in a shout out to, I have two shout outs today. First shout out is to Chess Cruncher TV. Keep putting out excellent podcasts, Chess Cruncher. Excellent job. And second shout out is to my Kindle book, Battling the Big Bad Baby Bar, Amazon Kindle. Definitely check that out. Okay, and with that, I will say goodbye until the next podcast, and best of luck on the bar exam.